Occupiers liability is the area of tort law that governs the duty of care owed by occupiers of premises to people who enter those premises and suffer injury or damage. The elements of occupiers liability are the existence of an occupier, the presence of a danger on the premises, and damage caused by that danger. The existence of an occupier means a person with sufficient control over premises to make them responsible for safety, as shown in Wheat v. Laken, where both the brewery and the manager were occupiers. The presence of a danger on the premises means a state of the premises or something done or omitted there that creates a risk, as shown in Ward v. Tesco stores, where a slippery floor was a danger. Damage caused by the danger requires a causal link between the danger and the injury suffered, as shown in Jolly v. Sutton LBC, where foreseeable injury arose from a dangerous object. The Occupiers Liability Act 1957 sets out liability for lawful visitors, and the elements of this are the status of the visitor as lawful, the existence of a danger due to the state of the premises, and a breach of the common duty of care. The visitor must be lawful, meaning they have express or implied permission to be on the premises, as shown in Lowry v. Walker, where habitual use created implied permission. A danger due to the state of the premises includes physical features or hazards, as shown in Glasgow Corporation v. Taylor, where poisonous berries created a danger. A breach of the common duty of care occurs where the occupier fails to take reasonable care to keep visitors reasonably safe, as shown in Latimer v. AEC, where reasonable precautions were sufficient. The defenses for occupiers' liability for lawful visitors are warnings, consent, and exclusion or limitation of liability. A warning can be a defense if it is sufficient to make the visitor reasonably safe, as shown in Ray v. Mars, where a clear warning reduced liability. Consent is a defense where the visitor willingly accepts the risk, as shown in Sims v. Lee Rugby Football Club, where the claimant accepted inherent risks. Exclusion or limitation of liability can be a defense subject to statutory control, as shown in White v. Blackmore, where liability was successfully excluded. The Occupiers Liability Act 1984 sets out liability for trespassers, and the elements of this are awareness of the danger, knowledge of the trespasser's presence, and the reasonableness of offering protection. A trespasser is a person who enters premises without permission or exceeds the scope of any permission given, as shown in the case of the Calgarth. The occupier must be aware of the danger or have reasonable grounds to believe it exists, as shown in Reville v. Newbury, where a known risk was present. The occupier must know or have reasonable grounds to believe that a trespasser is in the vicinity of the danger, as shown in British Railways Board v. Harrington, where frequent trespass was known. It must be reasonable in all the circumstances to expect the occupier to offer protection, as shown in Tomlinson v. Congleton Borough Council, where it was not reasonable to protect against obvious risks. The defenses for occupiers' liability for trespassers are warnings, the obviousness of the risk, and voluntary acceptance of risk. A warning may be a defense if it gives adequate notice of the danger, as shown in Westwood v. Post Office, where warnings reduced liability. An obvious risk can be a defense where the danger is clear and apparent, as shown in Tomlinson v. Congleton Borough Council, where the risk was obvious. Voluntary acceptance of risk applies where the trespasser knowingly accepts the danger, as shown in Ratcliffe v. McConnell, where the claimant accepted a clear risk. Thank you for watching this video on occupiers' liability. I'll see you in the next one.